Over 100 years ago, in 1923, Alice Paul and Crystal Eastman wrote and presented the Equal Rights Amendment for the first time at the 75th anniversary of the Seneca Falls Convention. After a century-long battle for sex equality and reaching the required 38 state ratifications with Virginia's action in 2020, the ERA should be published as the 20th Amendment to the U.S. Constitution. But we are still waiting, so what's the holdup? There really shouldn't be one at this point, but a time limit included in the preamble of the amendment when it was first passed in Congress seems to be the excuse used by politicians to not move forward with the publication of the ERA. Let's review where we are today. March 22, 1972. Congress passed the ERA with two-thirds majority support and sent it to the states for ratification. On January 6, 2020, the Department of Justice's Office of Legal Counsel, or the OLC, under the Trump administration, published an opinion citing the time limit in the 1972 joint resolution as setting a permanent expiration date for the ERA, despite analysis by the nation's leading constitutional scholars to the contrary. Following this memo, the U.S. Archivist stated that he would abide by the opinion published by the Department of Justice's Office of Legal Counsel, under Attorney General Bill Barr. On January 27, 2020, Virginia became the 30th state needed to ratify the amendment. Article 5 of the Constitution required 3/4 of the states to ratify an amendment. Upon receiving Virginia's ratification of the ERA, the U.S. Archivist does not publish the ERA. On October 21, 2021, for the 50th anniversary of the House passage of the ERA, the House Committee on Oversight under Chairwoman Carolyn Maloney, a long-term supporter of the ERA, held a House Committee hearing to explore the current status of the amendment and to examine the final steps necessary to certify it and publish it as a 20th Amendment to the Constitution. January 26, 2022, the Office of Legal Counsel clarified that their 2022 opinion is not an obstacle either to Congress's ability to act with respect to ratification of the ERA or to judicial consideration of the pertinent questions according to the DOJ under Attorney General Merrick Garland. January 27, 2022, or the 2-year anniversary of the ratification of the ERA, the date the amendment should have taken effect as per the third section of the amendment, a statement from President Biden was made on the Equal Rights Amendment. Today, as the House announces a resolution on the Equal Rights Amendment, I once again want to express my support for the ERA loudly and clearly. I've been a strong supporter of the ERA ever since I first ran for the Senate as a 29-year-old. We must recognize the clear will of the American people and definitively enshrine the principle of gender equality in the Constitution. It is long past time that we put all doubt to rest. I am calling on Congress to act immediately to pass a resolution recognizing ratification of the ERA. As the recently published Office of Legal Counsel memorandum makes clear, there's nothing standing in Congress's way from doing so. No one should be discriminated against based on their sex, and we, as a nation, must stand up for full women's equality. March 22, 2022, the 50th anniversary of the passage of the amendment from Congress. Then on September 28, 2022, the state of Illinois and state of Nevada versus David Ferrerio. D.C. Circuit set oral argument in the case for September 28, 2022. January 24, 2023, Senator Cardin and Representative Presley introduced joint resolutions SJ Res 4, HJ Res 25. February 28, 2023, the D.C. Circuit upheld the dismissal of Illinois versus Ferreiro, ruling 3-0 that the states failed to prove the archivist was obligated to certify and publish the ERA, or that Congress lacked authority to impose a time limit on its ratification. The court's decision emphasizes that the time limit issue remains unresolved and left the matter for Congress to decide. February 28, 2023, Senate Judiciary Committee held hearing on the Equal Rights Amendment. The hearing emphasized bipartisan efforts to pass the ERA as the 20th Amendment. With Virginia's ratification in 2020, the ERA reached the required 38 states. On March 28, 2023, Representative Cori Bush and Representative Presley launched the first ever ERA caucus in the House of Representatives. Then, on April 27, 2023, SJ Res 4 received a bipartisan majority vote in the Senate but did not receive the required number of votes to pass closure. Leader Schumer entered a motion to reconsider so that the bill can be brought up again later in the session. On the same date, the White House voiced support for the ERA. July 13, 2023, Representative Cori Bush announced a joint resolution with Senator Gillibrand. The resolutions affirmed the ERA as the 20th Amendment and called on the archivist to publish it immediately. July 19, 2023, Representative Presley announced discharge petition on HJ Res 25, the resolution that affirms the Equal Rights Amendment as the 20th Amendment to the Constitution. October 16, 2023, at the 139th International Covenant on Civil and Political Rights session and in partnership with Equality Now and other organizations of the ERA Coalition, urged the United Nations to remind the U.S. to honor its ICCPR commitments and publish the Equal Rights Amendment. December 13, 2023, we marked the 100-year anniversary of the introduction of the ERA in Congress by launching our Not One More Year campaign, calling for action without delays or excuses. March 11, 2024, In partnership with Equality Now and others, the ERA Coalition hosted a panel at the United Nations Convention on the Status of Women, highlighting the needs for the ERA in the United States, U.S. economic inequality, the Equal Rights Amendment catalyst for change. July 4th, 2024, Elect Equality is launched ahead of the November elections. July 12th, 2024, Discharge Petition HJ Res 25, the resolution led by Congresswoman Ayanna Pressley, has 214, putting us closer to the required signatures to affirm the ratification of the ERA. Big news. On August 6th, the American Bar Association approved Resolution 601, showing strong support for making the Equal Rights Amendment the 20th Amendment to the U.S. Constitution. We will continue to work for the publication of the 20th Amendment. We are closer than ever, and we are not giving up until sex equality is reality for everyone in our nation. Because equality of rights under law shall not be denied or abridged by the United States or by any state on account of sex.